Hello everyone, this side Nitu Singh, Assistant Professor of Indraprastha Law College. So, in our last lecture, we also discussed about the delay in justice, and that is about delay in criminal justice. So, in this lecture, we are going to discuss the delay in civil litigation. So, let's start. Okay. As we know, justice delayed is justice denied. It is imperative that a person gets justice within time. Obviously, understood है कि आपको justice एक within fixed time period में या फिर एक reasonable time period में मिलनी ज़रूरी है. Refusal of timely justice is equal to a denial of justice. The existing justice delivery system is not proper and takes an आप कह लो it's take a very long time with the case, so it is due to the backlog of cases. Exactly. So according to National Judicial Data Grid, there are 3.3 crore cases. I have given some data relating with justice delayed. Okay, so the main cause of delay in civil litigation is the complex procedure of the Civil Procedure Code 1908 and overburdenance of case for which the present judge's strength is totally deficient. Okay, so the number of the pending cases in India is growing at an alarming rate every day, and the litigation face weak purposes prospectus of their cases being deferred rapidly. Okay, so the reasons of delay in justice are very much same in both the scenarios, or delay in criminal justice or delay in civil justice. Okay, so the most important purpose of the judiciary is to ensure the protection of the innocent. Delay invites a lot of problems, and prolonged pendency of cases cause serious problems to the public. An effective, fair, and expedient trial is the fundamental right of every citizen, as we know according to our constitution. So the Supreme Court in recent years, by invoking Article 21, have tried to give some relief to people in this regard. Some of the dangers which could be caused as a result of the delay in litigation, वो कौन से हैं? Faith of the common people in judiciary loses. Exactly. Non-appearance of the witnesses, wrongdoer gets the chance to avoid litigation, and remedies made available are of no use. Memory of the witness and the judge fades. Mental and physical agony to the party to the suit. Okay, so डिले इन जस्टिस से कौन से सिचुएशन हमें फेस करनी पड़ रही है? सबसे पहली बात, जो जुडिशरी का जो फेथ है, जुडिशरी में जो कॉमन मैन का फेथ है वो धीरे धीरे खो रहा है. नॉन अपेयरेंसेस ऑफ द विटनेस, और जो रॉन्ग डूअर्स हैं दे गेट्स द चांस टू अवॉइड लिटिगेशन, एंड जो रेमेडीज अवेलेबल हैं दीज रेमेडीज और नो उनका कोई यूज़ नहीं है ऑब्वियसली. सो मेमोरी ऑफ द विटनेस एंड जजेस फेट्स एंड मेंटल एंड फिजिकल agony of the to the party to the suit. Okay, so okay, so these are some this is the introduction part, and moving next to the next slide. This is cause of delay. What are the reasons of cause of this delay? So there are numerous reasons responsible for the resolution of cases in a timely manner. सबसे अगर मैं पहली बात करूं, जज सिटीजन रेशियो एंड वैकेंसीज ऑफ द जजेस, ये लास्ट लेक्चर में भी हमने डिस्कस किया था, सेम प्रॉब्लम वहाँ पर भी. एंड डेफिशिएंट नंबर ऑफ कोर्ट्स. एग्जैक्टली. एंड फ्रीक्वेंट एडजर्नमेंट, ट्रांसफर ऑफ जजेस, ह्यूज नंबर ऑफ अपील्स, नॉन compliance with the provision of section 89, non-appearance of the parties, non-adherence to order 10, and delay in the filing of written litigation. These are some reasons जो कि क्या है आपके जस्टिस जो आपकी लिटिगेशन में जो डिले है उसके रीजंस हैं वो क्या थे? जज सिटीजन रेशियो एंड वैकेंसीज ऑफ द जजेस, डेफिशिएंट नंबर ऑफ कोर्ट्स, फ्रीक्वेंट एडजर्नमेंट्स, ट्रांसफर ऑफ जजेस, ह्यूज नंबर ऑफ अपील्स, नॉन अपीयरेंस ऑफ द पार्टीज, डिले इन द फाइलिंग ऑफ रिटन स्टेटमेंट्स. दीज आर सम रीजंस ऑफ डिले इन जस्टिस. ओके, so over the years, the numbers show that the cases filed in the courts are increasing day by day, due to which they are getting piled up. Currently, there are 3.5 crore cases pending in the you can say Supreme Court, High Courts, and the lower courts, resulting in an increased backlog of cases in the court. So the reality is that the courts are overwhelmed with cases, and even though an increasing number of courts are being set up, so the number of cases that are recorded isn't adequate to match with the expanded number of cases. In the last decade, the pendency of cases has significantly increased. So the primary reason is that more number of cases are filed every year than the number of cases disposed of. Okay, so the growing number of backlog cases and non-compliance with the provisions of the code have eventually led to an increase in litigation. So this is the reason of increase in litigation. Okay, अमेंडमेंट व्हाट आर वी डूइंग रिगार्डिंग दिस, हम कर क्या रहे हैं, हमारे जो स्टेप्स हैं वो क्या लिए गए हैं. सो अमेंडमेंट्स, देयर आर टू मेन अमेंडमेंट्स. दीज आर अमेंडमेंट ऑफ 1992 and 2002. Okay, the code of civil procedure have been considerably changed in the year 2002. Amendment to the code was also made earlier in the year 1999, but it was not made viable. Both of the amendments were made effective in July, on 1st July 2002. So the principal reason for the amendment to the code was to guarantee expedient disposal of civil cases represented under CPC. Okay, so I have given you some primary features of these amendments. Okay, these are section 26, institution of suits; section 27, summons to the defendant; section 89, settlement of dispute outside the court; section 100A, no further appeal in certain cases. These are some primary features of the amendments. जो हमने क्यों डाले amendment? To revoke the delay in litigation. Okay, yeah. Section 102, no second appeal in certain cases. And order 5, issue and services of summons; order 6, pleading generally; written submission; adjournment. These are some primary features of the amendment of these are some primary features of the amendment of 1992 and 2002 को एक साथ अगर मैं लेके चलूँ तो यहाँ पर मैंने आपको कुछ amendments नोट डाउन करके भी दिए हुए हैं. जस्ट गो थ्रू विद दैट. ठीक है, ओके. हमारी CPC में ये अमेंडमेंट्स आपको मिलेंगे. नेक्स्ट अगर मैं बात करूं, देर आर सम प्रपोज्ड रिफॉर्म्स ऑल्सो, जो हमने ऑलरेडी प्रपोज्ड हैं और हम प्रैक्टिकली अभी यूज़ करना शुरू कर चुके हैं. दीज आर फास्ट ट्रैक कोर्ट्स, वी कैन ऑल्सो कॉल दैट FTC, फास्ट ट्रैक कोर्ट; लोक अदालत्स एंड मोबाइल लोक अदालत्स; कॉमर्शियल कोर्ट्स; फाइलिंग अप ऑफ वैकेंसीज ऑफ द जजेस एंड इंक्रीज इन द नंबर ऑफ कोर्ट्स. ओके, एंड रिडक्शन ऑफ डिले इन फाइलिंग ऑफ रिटर्न स्टेटमेंट्स; अननेसेसरी एडजर्नमेंट. ये सारी क्या है? दीज आर द प्रपोज्ड रिफॉर्म्स जो कि हम क्यों लेकर के आए हैं, ताकि जो हमारा डिले इन लिटिगेशन है उसको थोड़ा सा कंट्रोल हम कर सकें. ओके, तो आई हैव गिवन यू सम इंट्रोडक्शन अबाउट द डिले इन सिविल लिटिगेशन, एंड आई हैव ऑल्सो already told you the causes of delay. Okay, and causes of delay, one more thing. Yeah, कॉजेज ऑफ डिले क्या थे आपके? जज सिटीजन रेशियो जो है हमारा, दैट इज़ वेरी बैड, एंड डेफिशिएंट नंबर ऑफ कोर्ट्स, फ्रीक्वेंट एडजर्नमेंट, ट्रांसफ़र ऑफ जजेस. तो अगर मैं बोलूँ आपको कि आपके ये कॉजेज ऑफ डिले हैं, तो आपका जो अमेंडमेंट है 1992 एंड 2002 इन CPC, तो वहाँ पर अगर आपको बोला जाए कि वो अमेंडमेंट्स किससे रिलेट करते हैं, तो यू कैन पुट ऑल दीज कॉजेज ऑफ डिले. ओके, सो देयर आर वन मोर इम्पॉर्टेंट थिंग, दैट इज अमेंडमेंट ऑफ 1992 and 2002 in CPC. Okay, and what are the primary features of the amendments? Institution of suit, summons to the defendant, settlement of dispute outside the court, and no further appeal in certain cases; no second appeal in certain cases; issue and services of summons; pleading generally; written statement, and adjournments. Okay, and there are some other proposed reforms also. These are fast track court, lok adalat, mobile lok adalats, commercial courts; filing up of vacancies of the judges and increase in the number of courts; codes, adherence to section 89 of CPC, unnecessary adjournment and direction of delay in filing of written statement. These are some proposed reformed. Okay, so every person here I have given you a conclusion to complete your answer. That is, pendency of cases for a long time defeats the whole idea of justice and lose people confidence in the judiciary. With the number of cases currently pending in India, there are certain cases that are pending in the courts for more than 10 or 20 years. Okay, so it is not suggested that there should be justice quickly, but without observing the procedures of the code and hastily disposing of the cases by the judges without considering the material evidence and due hearing in every cases. So the changes brought by the amendments in 1999 and 2002 to the CPC are basic in nature, yet have sweeping results for as far as working of civil courts in the nation is concerned, if they are properly followed. Okay, so uh, in our last lecture we just discussed about the delay in criminal procedure or criminal cases, and in this lecture we discussed about the delay in civil litigations, and I have also told you the causes of delay in civil litigation and amendment of 1992 and 2002, and the primary features of the amendments, and also some proposed reforms like fast track court, lok adalat, mobile lok adalat, commercial courts, and filing up the vacancies of the judges, and reduction of delay in filed of written statements and unnecessary adjournments. These are some proposed reforms. 1992 एंड 2002 के अमेंडमेंट के साथ ये, और आपके पास कुछ 9-10 रिफॉर्म्स हैं जो कि ऑलरेडी प्रपोज्ड हैं. ओके, सो I think that's it for this lecture. We'll meet in our next lecture with a new topic. Thank you so much.